why I am seeing images of tear gas being deployed and reading reports that there were no warnings given before it was deployed out in the field. Where I am seeing images of ICE agents, and if I cannot see the alphanumeric identifier on the pictures that I'm seeing in the paper, why is that so? The other thing is, I am now modifying the TRO. And I am adding that all agents who are operating in Operation Midway Blitz are to wear body-worn cameras, and they are to be on.
Everybody hear that?
So, Mr. Skrzydlewski, I'm not happy. I'm really not happy. And before I jump into any conclusions, I want to hear from the field officer on Monday on what's going on. I want to know how this order was disseminated. I want to know what people were told they had to do and what they could not do to comply with the order, and specifically what is being done to comply with this order. So why don't I hear from you first about anything you want to say, add any concerns of mine that you want to address.
Thank you for the opportunity, Your Honor. As far as what you've seen on TV or social media, I don't know all of what you've seen. Plaintiffs have raised with us two specific incidents that were widely reported. One in Albany Park, where the reporting, Your Honor, is just inaccurate. And I don't know whether that's true in all of the cases that you've seen, but at least in that case, the reporting says that no warnings were given before tear gas was deployed. And that's just simply not the case based on what my client's preliminary review of those facts has shown. So I would encourage the court or ask the court rather, to not make amendments to the TRO on the basis of one-sided and selectively edited media reports that we've already confirmed in at least one case are figuring out the full story. It's very easy to start a video, after a warning has been given. And of course, that's what you would expect a video to pick up, right? When everything's peaceful, people are less inclined to film things. And then when things get out of hand, warnings are given, then the phones come out and individuals may start filming. And so what we see is not always the full story. And we know that that's the case in at least the Albany Park incident. As for, I would just ask...
What about the incident that occurred on the southeast side? The article that I have from the Sun-Times was dated on the 14th.
Your Honor, plaintiffs haven't raised that particular incident with us, so I don't have any. We haven't looked into that.
All right. So hold on. So I want information on Monday on this incident that occurred It would be 105th Street and Avenue N on the southeast side of Chicago that occurred on Tuesday. The
District Court.
other question that I have arising out of this incident on Tuesday as well is that at least according to the Sun-Times,
This is Chicago.
that there was a car chase in a residential neighborhood. And I have to tell you again, like, there's a reason the Chicago Police Department has policies about car chases and where they occur and when you need to stop. And I would like information, as we're going to talk about that incident on Monday. I would like information about how and why that, what the agents are being told is okay. Because again, right, here's the basis of my concern.
This is the judge telling
We're
them that.
not on the border. We are in an urban, densely populated area where crowds are going to converge when there's a commotion, where appropriate crowd control is important, where trying to apprehend and detain people is very, very different when you're in an urban setting than when you're out on the border. And so, as we're working through these issues, I want to make sure that DHS is aware different settings are going to call for different policies. Underlying all of these policies, obviously, is that everyone has to abide by their constitutional obligations. But I am profoundly concerned about what has been happening over the last week since I entered this order. So I hear you that, what I am seeing is what's in the newspaper, what's in the Chicago Tribune, what's in the Chicago Sun-Times, both of which are mainstream newspapers. What's being what's being shown on WTTW and WGN and NBC5 and ABC7. I haven't seen CBS, but I have seen those over the last week. And, sure, it could certainly be that these journalists got it wrong, which is why I want to hear from the field director on Monday. but there's enough there that definitely gives me pause and concern, which is why I brought everybody in today. So why don't I hear from the plaintiffs, and then I'll come back to you, Mr. Skedulewski.
Judge, I suppose we'd have one additional request for modification of the TRO to change the conferral requirement in advance of reporting what we consider to be violations. We reached out to the government on Friday to confer and didn't hear back, likely because of the holiday, until Tuesday. And so we waited to confer, tried to make a good faith effort. I think we would like to file a daily outline of incidents that we consider to be violations of the TRO if the court will accept that.
I still think the meet and confer is important. You know, certainly with these incidents,
She requires them to meet before they come to her.
you know, it might be that the parties are just at a impasse, right? You say this is a violation, the government says no.
Yeah.
But it certainly could be times where, as Mr. Skedulewski noted, you know, what we see is it doesn't appear that a warning was given, but we go back, and that's why I want the body cams, is because that's a good way, right, of easily going back, and you can look at the video.
She's going to require body cams now.
Were there warnings given? And if it's running, then great, right? We look and see, yep, warnings were given, not a violation, end of story. So I think it is worthwhile to have the meet and confer in place. I can understand how we're kind of where we are right now, given the holiday weekend. But I do want to keep this 24-hour meet and confer in place.
All federal agents.
To give the parties time. If there is something where we've got crossed wires or misunderstandings, we can take care of that.
Very good, Judge.
Anything else?
Do you want a new proposed TRO with the language about body cams that you read into the record submitted?
Yes.
Okay. And then we have a motion for expedited discovery up, and then...
I saw that. So first, Mr. Skedulewski, is the government going to be prepared to go forward with a preliminary injunction hearing next Thursday?
No, Your Honor, we had conferred with plaintiffs as to an alternative schedule, and we made our proposal. Then they had a counter proposal. I'm happy to lay that forth now. We file a joint as reported if the court prefers.
No, you can just tell me now.
Sure. So we proposed having the preliminary injunction hearing on November 5th. That keeps the hearing within the sort of 28-day limit of the TRO. We propose that plaintiffs file their motion this Friday, tomorrow, the 17th, with us filing a response on October 30th. That's 13 days to respond. They would have had about 16 days to prepare the motion. We think that's pretty balanced. And then plaintiffs can reply sometime before November 5th, whether that's the 4th or the 3rd. We leave that to them. Yes, that was our proposal, Your Honor. I would like, whether now or later, Your Honor, to make a few additional points about the proposed changes to the TRO as well, but I leave that to the court.
Sure.
So,
hold on. Let me put this to bed so that I don't forget. Let's start with the date first. Does the 5th work for a PI hearing?
Yes, Judge.
Okay.
I believe that with the 2-week extension, the 6th is also available.
I prefer not to do the 6th.
Okay.
So, yeah, let's do the 5th. And we'll start at 9. And then, in terms of a briefing schedule, what do you want to do?
Judge, from plaintiff's perspective, we are going to follow 3 things: an amended complaint, motion for preliminary injunction, and the class cert motion that the court asked for. We're going to file them all at the same time. We prefer to do that Tuesday or Wednesday of next week because we are going to submit additional evidence of compliance or lack thereof with the court's TRO at the same time. I think that we can submit the reply as close to the government's response to our filings as the court wants. We don't need a lot of room there, we don't think, but we would prefer to file those 3 things to kick off the PI process next Wednesday.
All right, what? All right, so Mr. Scheduleski, if I gave the plaintiff until the 22nd, and I gave you to the 31st, would that work for you or no?
Hearing now that, yeah, go ahead, sorry.
And I was going to say, I understand
He just had a
that
baby.
at some point in this process, you're going to switch out and we're getting somebody
Or
else,
he's about to have a baby.
right?
At least for a period of time, that's right.
Right. So does that work with whoever is coming in for you?
I think given the fact that there will be new evidence and that evidence is presumably going to be cumulative from the TRO, I mean, I think Monday would be more realistic for defendants to be able to put a full record before the court. The 20th for plaintiffs to submit all this. That would leave us 10 days to respond. And again, it's not so much the briefing, Your Honor, as it is evaluating the evidence and tracking down everything with the client. So we can make sure that we've got a full picture.
All right, why don't I cut the baby in half? All right,
So to speak.
plaintiffs will have till the 21st, which is Tuesday. The government would have till the 31st, so that would give you 10 days.
Right now we're just working out the dates for this motion, so it's not...
That's workable, Your Honor. Thank you.
All right. And then, can I get a reply no later than the 3rd?
Sure, Judge.
Okay. I just want to make sure that I've got enough time to sit with everything before the 5th.
Absolutely.
Okay. All right. So we got that done.
Yes, it's against Christina.
Can I raise one more point on
Sure.
that schedule, Judge? The government would like to do the hearing on paper. We think it's important to at least have a couple live witnesses at the hearing for the court to hear from. And so our preference is to do that hearing on the 5th.
Hey, Carol.
Yeah, I would be expecting that I hear from a few people, right?
And Diary of a Bluebird,
Because I
hello.
may have questions.
Your Honor, the government doesn't plan to put any witnesses forward on the 5th. Though plaintiffs, prefer to do so, we don't object to that.
Carol, I don't have access to my regular buttons right now, so I may need you to take care of a couple of things. You'll see.
The federal government's justification for the deployment of federal forces in Chicago.
Thank you.
Well, you mean,
Hey, Josh.
you mean
So some of the folks whose
DHS agent.
yes, or other officials in the government, we would call in our case to demonstrate that there is no justification for the action that the federal government has taken here. We, I suppose, don't have an objection to those folks appearing remotely if that is more convenient and it is acceptable to the court, but we would plan to disclose and call those witnesses in the PI hearing.
Okay. So, some of the folks that, you have mentioned in your motion, right, we're not calling Christino, and we're not calling Stephen Miller.
That's funny
We
because
can talk about Chief Bovino, maybe, but
no, she's just saying. No, the government didn't want to call them up. The plaintiffs did, and she was like, "You're not. This is a district court in Chicago. You're not calling up."
Director is
No.
important, right? Mr. Skazulewski, if I am correct, is Field Director Hott, who
Like the
is
Chicago Field Director?
managing the operations here in Chicago, correct?
He's certainly involved, Your Honor. Whether he's the only one managing, I would leave that to him to discuss.
Right.
But I've been
know,
an AAG before and been in this situation where they're like, "Yeah, we need to call the governor for this," and it's like, "No, you don't.
He's
No."
overseeing kind of the day-to-day ground operations in Chicago, correct?
Lee Regard, I can explain that, but I don't want to do it right now because I don't want to talk over him too much.
How a
Sorry.
field director operates, right? I'm not.
It has to do with the power of a lawyer to subpoena people.
There are many subcomponents here that are involved, and they only have management oversight over certain personnel, not others.
Okay, so, let's start there and see where we go. But, no, I'm not gonna have Christine in at this point. I think
It's not that she might never do it, but
achieve
not
what
at the
we
beginning.
need to achieve, short of that.
Can I make one point on that point, understanding the court's
Sure.
preference? Our concern is that in these cases, the courts of appeals have expressed a real deference to the administration and a viewpoint that there is nothing for the federal bench to review if the administration has made a determination that the conditions on the ground in various municipalities in the United States require the deployment of force. It's going to be our position in this hearing that no such analysis has taken place. And this is pure ideological, viewpoint-driven deployment of federal forces in retaliation for views that the administration doesn't like. We would like to be able to show that, and we think it's important for us to try to put that in the record before the court. And so that's the reason that folks higher up the chain are on our list.
And I hear you, but at least and I know you're going to be filing an amended complaint, but at least on the operative complaint that I have, right, the issue is that DHS is using force
Thank you, Allie.
in a manner that violates the constitutional rights of peaceful protesters, journalists, and essentially clergy members. Whether the administration, what its ideological motivation is for having agents in Chicago enforcing immigration laws, it's kind of irrelevant based on this complaint. What I'm looking at is, how are these agents enforcing the laws? Are they doing so in a manner that is violating other people's constitutional rights? If that's the case, that has to stop, right? And these agents have to conform how they are enforcing the laws to the Constitution. What Secretary Noem or Mr. Miller or anybody else says, I don't really care, right? It's, are the agents being told on the ground that you have to use force commensurate with the threat that is there? And if you've got a bunch of peaceful protesters, if you have journalists, whether they're at the Broadview facility or they're out on the street in the Northern District of Illinois, then you can't shoot them in the head. You can't deploy tear gas. You can't use flashbang grenades. You can't drive a car through a crowd. So that's what my focus is. Should you file an amended complaint that, brings up other issues, we'll deal with it. But on this complaint, this is what I'm looking at. This is what the PI hearing is based on. So this is my focus.
Understood, Judge. Thank you.
Anything else?
On the remainder of our discovery, I sort of think we're into the discovery that's going to be allowed. We understand the court to be saying taking the deposition of Hott might be relevant to the upcoming PI hearing.
It might be. I think I'm going to hear from him on Monday.
Yep.
And if there's more after that, yes, I would allow you to depose him.
Okay, and then I think we would ask for Bovino, certainly, who is
The judge
directing the operation in Chicago, much like
is the
he
woman
did
speaking.
in Los Angeles. And then if there is a third dep, it would be Para, who's the deputy chief, and the government has relied on Para so far in these proceedings.
Okay.
And we can get those depositions done as quickly as the court orders, and they can be as long as the court orders. We don't think we need long depositions.
Yeah, I don't think they need to be long depositions.
And then the last two pieces of the discovery motion are, we don't think interrogatories and requests for admission are going to be useful at this stage, but we do think that document requests will be, particularly requests directed at justifications for the operation, the guidelines that have been given to agents in connection with Operation Midway Blitz. And so I think in our motion we said we'd like to serve a complete set of Rule 34 requests. I think we could serve 10, confer about them with the government on an expedited basis, and get those documents that we need into the record. So I guess we would ask for 10 Rule 34 requests and then mutual disclosure of witnesses and exhibits at some point before the hearing.
Yeah, so let's, what I would like the parties to do is, in terms of discovery, that you meet and confer, because Mr. Skedulewski, I don't know that you've had a chance to really talk about it. This motion was filed yesterday, so, and late yesterday, so I suspect you haven't really had a chance.
We conferred yesterday about it, and they object to any discovery.
All right, go ahead, Mr. Skedulewski.
Yeah, thanks, Your Honor. We think that if the plaintiffs are going to seek production of documents, that those requests, the specific requests, should be filed, with the court, so that you have a chance to respond to whether or not this motion for expedited discovery generally, and any specific requests, whether it be depositions or production of documents, are proper or improper. We expect, based on what we've seen in the motion for expedited discovery, to oppose. We'd like to put a brief before the court as to why the court should not grant expedited discovery, but we think it'd be much more useful to the court if we could do that with whatever requests for production the plaintiffs are looking for in advance.
All right, so then what I'd like the plaintiffs to do is, now that you understand where I'm coming from, file a new motion for expedited discovery and lay out what it is specifically you're looking for. Then, Mr. Skedulewski, if you can respond, so if you can do that today, if you could respond by the end of the day tomorrow, and then we can take it up on Monday. And at least we're not burning time before the hearing. So then I can tell you yes or no on what you can do before the hearing. And then, Mr. Skedulewski, I know you wanted to talk.
Right now they're working on discovery, which is evidence. Which evidence they're going to pass back and forth.
If I could as well, just note, it sounds like the court has already made up its mind as to calling Director Hott into the court on Monday. I'll just note, that's a quick turnaround.
I can't remember why I laughed.
Incidents, Director Hott may not have been present at them. He's going to need to review documents, perhaps speak to his officers to get a full picture of what happened in any of these particular incidents. So I would ask for a bit more.
No, he can tell me, I don't know. He can tell me, I haven't had a chance, right? But some of the things, I think he can figure out sort of what happened. And I think that he would be able to, and I would hope, right, as field director, that he's got enough information as to what is happening day to day that we can have an intelligent conversation about what's going on. So, I don't expect him to be able to talk about the nitty-gritty of this agent was on this corner at this particular time, and this is what was done. But generally and broadly speaking, I think, yes, he should be able to tell me what's been happening over the last week. And that's what I want to happen on Monday. So I don't expect him to have all the answers, but I expect him to have some, based on the fact that he's the field director.
Understood, Your Honor. And I'll move on then to the the proposed modification to the temporary restraining order. My understanding from ICE is that the body camera program has not been rolled out sort of enterprise-wide. That is, it has only been, acquisitions have been made, and the program has been implemented only in select areas of responsibility. The Chicago AOR is not one of them. And so, if the TRO goes into effect...
I'm sorry to interrupt you. Just what's AOR?
Oh, apologies, Your Honor. It's area of responsibility. It's
Okay.
the region, the Chicago region that includes Illinois and surrounding states.
Okay, and for the Chicago region, does that cover?
Basically, they don't have body cameras.
Tell me how are agents
Yeah.
assigned? So,
Remember
like,
what's
for
happening this weekend,
example,
guys.
I know that we've got a lot of ICE agents here that normally aren't assigned to Chicago, right? For this
That's right.
particular operation. Okay.
That's right.
So, does the body cam rollout, for example, if it's Texas, right, where everybody, just as an example, everybody has body cams in Texas. If you are in Texas, but you are now assigned to Chicago for this operation, do you then have a body camera, or do you see where I'm going?
Yes, Your Honor. I think there are likely some agents in the Chicago AOR who have body cams from, if they come from an AOR that has already rolled this program out. We don't know how many that is. I've asked the client about that, but they haven't been able to identify that yet.
That's
and
not...
they might not be able to because the numbers are changing probably daily, and it's not a fixed amount. Considering the lapse in appropriations that sort of we're dealing with, I don't believe that it would be possible on a short timeline to roll out a body cam program in the Chicago AOR for ICE. My understanding for CBP is that it's been rolled out more broadly, and so it may be more workable for CBP. But in any event, these sort of the policies associated with these cams do not provide for continuous recording. And that's for a host of reasons. Some of those are listed in the policy documents filed by both plaintiffs and defendants last week. Privacy concerns, respect for First Amendment rights, law enforcement sensitive information, and so on, all counsel against a continuous recording. So the policies, I believe, require if an agent is a participant in the program, that they record whenever they're engaged in, quote, law enforcement activity, and that's defined in the policies, or something to that effect, Your Honor. So we would oppose, of course, this modification, but if the court is set on it, we would at least ask that it model the policy documents that we've provided so that the agents at least have some idea of what they're supposed to be doing, and they've already been trained on it, and that there be a carve out for those agents that don't have these cameras.
Right. So, what I'd like the parties to do is meet and confer about this modification. I understand, and I would not require people to turn on a body camera that they don't have. But if they do have a body camera, and this, as you're talking to Field Director Hott, this is something that I would want information on, is how many agents, whether it's ICE or CPB in Chicago, that are working on Operation Midway Blitz how many of them have been issued body cameras? And does it look like the Chicago region is supposed to be getting them? If so, when are they supposed to be getting them? Again, I want to make it workable, and we can use I don't know why.
Well, this
there's somebody,
TRO would require
I
them to
think,
keep it on.
on the line that's not muted. Okay, if
I just got another violation, guys.
I've got the CPP
TikTok keeps violating me for doing this.
policy and the DHS policy regarding body cameras, like we did with other aspects of the TRO. I wanted to mirror the
Unoriginal
language
content.
of the policies so that people understand.
I'm also
and
on
they've already been
YouTube.
trained on how and when they need to turn their cameras on. So whatever the definition of law enforcement activity is, that's what we should be mirroring. And Mr. Skedulewski, and you can tell me you don't know if you don't know, but from my memory reading these, that a law enforcement activity would include, for example, if they're out in the field and they are
Morning, Crispus.
going to detain someone or question someone to ascertain someone's immigration status, and a crowd forms, that would fall under a law enforcement activity. Or am I missing something?
I don't know for sure, Your Honor. I wouldn't want to speculate. I think that the definition was relatively broad. It would probably cover a lot of different scenarios. Maybe that would be one of them.
Okay, thank you,
I'm not
Carol.
sure.
Okay, so I just want to make sure that in the, in this modification to the TRO, that it's clear, right, that essentially when they're engaging in the
Welcome,
operation
Keisha.
of their enforcement duties, that we turn the cameras on.
Okay.
And frankly, Mr. Skedulewski, this is going to help the agency, right? If there are issues and we see, either I have a concern or plaintiff's counsel has a concern and comes to you and says, hey, we think there was a violation here.
Sorry.
We can go back. That's why we've got the cameras for a reason, right? Is you can go back and document and say, hey, we pulled
That's
it.
all right on time.
We looked at it. Here it is. The warnings were given. This was,
She's right, if they're giving the warnings. So that's the question.
Coming from the crowd at this particular time.
This is the big question.
And that's the nice thing about body-worn cameras, is that they pick up events before the triggering event happens. And yeah, once somebody hits the ground, all the cameras come out, all the cell phones come out, and you don't see what happened before that. So at least we'd have a much better picture of what's going on and a much better understanding of whether any violations occurred.
You understand the court's reasoning, Your Honor. I would just like, if I can, to get it into the record that we do oppose this modification, not only because it's not tethered to any specific complaint
Dead Peter.
or injury that the plaintiffs have leveled. They haven't alleged
Fancy
they're
mug.
able to find out to DHS. They found the agency that they're looking for. But also, and maybe more importantly for the court's consideration, it's not a simple matter to pull these videos. My understanding is that it takes a considerable amount of time. They're highly secured for obvious reasons to protect, the individuals who are being filmed and the officers. Redactions are required to protect people, the public and officers alike. So this is part of the unworkability of this TRO in general, is that it will require a tremendous amount of resources for DHS to sort of each time plaintiffs think that the TRO has been violated, and as we've already seen, they think that happens essentially every time there's a forceful interaction between DHS and the public. That's going to mean, a nonstop sort of crew dedicated to, reviewing, redacting, and of course, with the body cam footage is extensive, right? So even if you're only filming during law enforcement operations, that could mean dozens of hours, for one officer.
Dozens?
In a given week. And so that's all got to be viewed, pared down. I mean, it's not as simple as it might seem.
Yes, it is.
At first glance.
Yes, it absolutely is.
I consider that in specific.
Oh, I consider it, and I hear it. There's, a simple way to not have to do that, though, right?
Oh.
So
I don't think that's an option. I think we're going to enforce federal law.
No, you can enforce the law, and I have never, ever, ever, since we started, taken the position that the government is not allowed to enforce laws that have been validly passed by Congress. Never. What I do have a problem with is if we have allegations that government agents are enforcing the law in a way that violates the Constitution. Don't violate the Constitution. We never have to pull any video from anybody, ever.
But respectfully, Your Honor, we're going to be pulling video each time there's an allegation of a constitutional violation, even if we've not committed any constitutional violations. And that's the merge.
Right. Right. But again, right?
There were no allegations a year ago.
We're not in these, if we don't get into these types of events where it gets, I'm seeing things, again, seeing photographs in the Sun-Times or the Citizen that cause me concern, right? So, it's not hard, and I'm not saying that it's, these situations aren't dynamic and they don't change, but really, it's not that hard. And so if everybody kind of follows what's outlined in this TRO, conforms their decisions and behavior to what the Constitution demands, then, it's all copacetic and we can go on and live our lives. So, I want to work out this modification, so we'll do that. And then you can send it in to me. And then did I tell you what time on Monday? I don't think I did.
Oh, no. Oh, don't wait until Monday. Please don't wait until Monday.
So how about 10:30 on Monday? Does that work for folks?
Works for the plaintiffs.
I couldn't quite hear you, Your Honor. Was that 10:30?
10:30?
That is disappointing.
Yes, that's fine.
Okay.
For me, that's also six enough. Better us.
Yeah, well, tell them that, we can,
Okay, all right. Final.
if he needs to change it,
That
that'd be later in the day, that works for me too. So, but let's shoot for 10:30. And again, you can appear remotely.
Judge, do you want the plaintiffs prepared to ask questions, or is the court going to ask questions?
If there are additional, if there's a set of questions that you'd like me to ask, you can just send them to me and send a copy to Mr. Skedulewski. But I was going to ask questions of Director Holt just to get a better idea of kind of what's going on.
That's to bring the director in. Okay, so that's the expedited hearing. Okay, so
all right. Is there anything else? Have I missed anything?
Not from plaintiffs, Your Honor.
Mr. Skedulewski, is there anything else you'd like to
I think she's a great
bring
judge.
up or ask?
Brother, and this may just be maybe I misheard something earlier. Did the court propose other modifications to the TRO besides the body-worn cameras?
No, that was it.
Okay. Nothing further.
That was it. Okay. All right, then I'll see everybody Monday at 10:30. If there's anything that the plaintiffs want me to ask Director Holt, sorry, if you get it to me by tomorrow.
No problem, Judge.
Okay. All right. And again, it would also go to Mr. Skedulewski.
Yes, Judge.
Okay. All right. We'll see everybody Monday then.
Thank you, Judge.
Thank you.
Thank you.
All right, everybody. So that was the hearing. Okay, so that was a lot. So there are a couple of questions. I'm going to kind of go in reverse order because I'm going to remember the ones that are most recent. This is now the third hearing I've sat through with this particular group of people. This judge, this attorney for each side, two of which we've all kind of sat through together. The first one I sat through was 3.5 hours long. So that was like an exercise in patience. But it was an exercise in patience for everybody. And I got to say, all of the parties were very, very cool in that one. I came out of that thinking, like, even, the government attorney in that was very professional, very cool. And it was a lot of, this is the thing that we want to get done. But the language, one group has this set of language, the other group has this set of language, but they're both trying to get this. They both agree that it's okay to get it to say the same thing. They just want to make sure that the language lines up, because the government attorney is relying on, government regulation books, and he wants to make sure that when this gets issued, the people who are reading it can read it. And so he's like, in our government regulation books, we call that thing this. So can we call it that instead so that it lines up with our regs? It was stuff like that. It went on, like I said, for 3.5 hours because they went through it word by word and changed everything. But everybody was really reasonable, really cool. There was very little actual disagreement under the circumstances. Now, of course, everybody's got to do their job. But I have to say that by comparison to a lot of these government hearings that I've been hearing, especially lately, this is pretty cool. A lot of things have not been so cordial. This is a pretty calm group of people. Everybody in here seems pretty cool. And one of the things that I really notice is that the government attorney keeps referring to the people that he's working for as client, which, have a little bit of flexibility about what you want to call the people that you're working for when you're a government attorney. And, it was kind of interesting. When I was a government attorney, I always referred to it as the government. The government thinks this, the government, agrees, the government disagrees, whatever. My job was to speak for the government, so I would do that, and I would always say the government, mostly because that's what the people around me did, so I just kept doing it. There are some people who take a much more high and mighty, not high and mighty, but, they put a lot more thought into it, and some people like to refer to themselves as the people, which is a thing that a lot of attorneys like to do when they work for the government. The people believe this, the people say this, the people say that. Totally cool, but it's a choice. It is something that a particular attorney decides to do because that's what they want to do. It's not like, as far as I know, no one requires that. Somebody might in like some jurisdiction, but as far as I know, nobody does. He keeps referring to everybody as the client. That's almost a little bit unusual for a government attorney. Now, he is listed as counsel. He doesn't have a name like AAG or anything like that. He's listed as counsel to the DOD or the DOJ, so I'm not sure what that means. He might have like a separate job of some sort. That might be why he's doing it, but I did look him up. But the fact that he's referring to them as counsel, I think, is at least, yes, as Eddie said, at least semantically an attempt to separate himself from them a little bit. He does not work for one of those law firms that are giving pro bono work. I looked that up, Allie. I wondered the same thing. I was like, what does this mean? Does this mean he actually works for, Dewey and Cheatham, and this is one of the... And no, he has been a government attorney for a while, but he is of counsel, as far as I can tell. So, I could be wrong, and I'm going based on his LinkedIn, so it's not like this is official records or anything. Okay, but yeah, everybody in there, I think, especially because they sat through that 3.5 hours together where they all had to be pretty cool with each other, I think they are relatively cool with each other. But it's sort of cool the way you are, like, imagine you're on opposing sports teams. Like, you're a little, like, a little separated from them. You're a little, like, against them, but at the same time, you're all playing the game together. So, but I do think the judge in general is relatively cool with all of them because they've all kind of been pretty okay through this process. Did they say another lawyer will be taking over? Yes, because he is about to have a baby. So he's going to be, I thought they said he'd already had the baby. No, he's about to have, about to have a baby. So he's going to disappear for a while. So, but anyway, that I did see a lot of you talking about that, and I just wanted to point that out, that they are very cordial. That is not the way it's going in every single courtroom, but it is the way it goes in a lot of courtrooms. Historically, it's the way almost every courtroom I've ever been in, mostly because, frankly, of who I am. I got that Midwestern friendly guy thing, and so I usually tend to be friends with my opposing counsel, and as a result, we all kind of interact well with the judges too. Just usually good, but that's not always there. Okay, so that was one thing. There's a lot going on, and I was paying attention to multiple things at once, and I did miss one very important thing, which I think some of you guys caught and I missed, which is whether what's going on Monday, and whether the new TRO, the adjusted TRO or the amended TRO is going to come out. So I think what she said is that she wanted the new order turned in by tomorrow from the CHC Council. She wanted them to write a proposed order and turn it in tomorrow. The thing that gave me pause is that they did ask a lot of questions about those cameras, and they didn't answer all of them. If they had answered all of them, I'd feel like she had enough information to fully write it. If I had to write it right now, and I wanted to write it in a way that it would be executable, I'm not sure I would feel like I knew what the answer was. And then when she scheduled another hearing for Monday with the director, I thought, uh-oh, that's when they're going to come in and see what the actual language is going to be. Which the reason that I'm concerned about that is that there is possibly, the word is that this could be one of the largest protests, certainly in recent memory, this weekend. And so this is a big concern, making sure that that this is taken care of. So, the body camera issue is an issue. Now, unfortunately, I was having a little bit of camera trouble right at the beginning, so I came in, a minute late. And obviously, once I come in, then people have to slowly find me, so it takes a little while to get in. So you missed the very beginning. She was coming in hot when I first came on. When I first called in, I think some of the first words I heard were, let's see. Oh no, I didn't write it down because I was trying to. The first words I heard were, I am seeing really bad stuff. I am very concerned. This is a problem. This is a problem. What's going on? I need to, why are people getting tear gassed? Why are people getting arrested? Why are journalists getting arrested? This stuff that I'm seeing on the news is bad. This is bad. What the heck is going on? And she was almost, I'm going to say a little flustered when it started. And the government's response was, well, because she had set something up in the original TRO that said, if there's a problem, if somebody comes to us and says, if the plaintiffs are made aware of one of these problems, she did say the end of today. Okay, good. Meeting Monday. Okay, did she say if the meeting Monday would be about the TRO or? Trying my best right now. Sorry, I just saw that. So what the government said was, when nobody knows when there's a problem until there's a problem. And so the 10 minutes before the problem, when there isn't a problem, nobody's recording. And so they tend to start recording once they realize that there's a problem and turn their camera on, which I will admit, there's a logic to that. There is certainly a logic to that. And actually, I could be glitching. It means I'm getting. So I am. If you're on TT, I might be getting clipped again. Sorry, guys. If I'm glitching, that's why they keep doing this to me. I got a warning, or another warning. So let me know if I'm glitching. Yeah, okay. The interview with the area director. So anyway, he said. Can you hear me? Okay. Well, I'll tell you what, guys. On the TT, what I can do is log out and log back in again. Oh, is it better? Okay. I am on YT here. I'll put the YT at up. If you want to go over there. Okay. Yeah. That platform really sucks. Whenever they don't like me streaming stuff, and so they. Okay. Okay, so, right, the point was, if they, that things are going to get missed. And so he's like, all you're going to see are the bad parts. And she said, okay, there's a logic to that. Fair. And so he's like, so you may not, they're supposed to give an order, a warning before they do this stuff. Nobody's going to record the warning because they're not going to know that there's a warning coming. She's like, okay, well, that's why we need body cameras, because those will record the warnings. So that's essentially where the body camera thing is. Now, here's the problem with the response, which is, area of law I practice is kind of broad because I've been a government lawyer, and so as a government lawyer, you do a lot of different stuff. I was a prosecutor, but I was mostly by accident. I was also a civil attorney, so I did a lot of business law and stuff like that. We have a huge military budget, and one of the things that he said, which is a party line right now, is that they can't afford it because of the government shutdown. But here is the thing, guys. There is money. There's a lot of money. They just have to decide how they're going to spend it. Hello. They have to decide how they're going to spend that money because it is limited. But they are making policy decisions on how to spend that money because they have it. They're just limiting it. So one of the things that usually happens during a government shutdown is that they shut down immigration courts because immigration courts are expensive and they're not a priority. Just getting people through those court systems, they can push those dates back. It's not a big deal, for a few weeks. Doesn't really matter. And so almost always they shut down immigration courts. They have not shut down immigration courts because their goal right now is to get as many people deported as possible in as short a period of time as possible, which means they are moving money over to things like that. They could be spending that money on things like body cameras to protect Americans' First Amendment rights. They are deciding not to do that. So I'm not saying that as a perspective or an opinion. That's just how math works and how money works. Money is fungible. And looking back at history. So, and that is what the judge was saying there. That, the judge was like, dial it back. So, but she did agree, frankly, 2 or 3 days would be tough if they don't have cameras now. But how many of them do have cameras now? And some of them might. So, yeah, I know. I wish it had been made a little more clear. And this is part of the problem is that, I wanted the other side to push back a little bit more, and they didn't. I'm not sure why they didn't, but I'm sure they had their reasons. They probably know this judge better than I do. And so this might be a judge who doesn't like to hear too much or something like that. You get to know a judge, and unlike the government attorney who's actually actively here in DC and calling in, the other attorneys are Chicago-based attorneys, so they probably know this judge and kind of know what she likes and doesn't like. That's one of the kind of tricks, is when you get to know a judge, you start adjusting your arguments based on what you know will work and won't work with that judge. Yeah, so that was one of the discussions. So we're going to see. She wants to require body cameras. Somebody here said that they're going out for the No Kings protest and bringing a body camera with them, which I don't think is a terrible idea. One of the problems that I had that he said is that body cameras are expensive, which they are not. The body cameras they're using might be expensive. He might be absolutely correct that they might be expensive for whatever reason. They might be, waterproof GoPros that, are all kinds of things and probably are unable to be hacked and all kinds of stuff. There might be things that make them more expensive. But what isn't expensive is digital video footage. And he said, it's more expensive to keep them on longer, which is not correct. Digital video footage, it's not film. It doesn't cost by the foot. So the government has plenty of storage. They can keep this stuff. And, he said, it'll take dozens of hours. Okay. Dozens? Less than a week? Okay. Well, let's go ahead and do that then. Dozens of hours? That's what you can, okay. Can people use drones? I don't know. That's going to be a local law. My guess is probably, I heard somebody say that there are parts of Chicago where you can. I don't know. Can't they trade out agents in Chicago that do have body cameras? Good question. There's only so much power, not necessarily that the judge has, but that she probably wants to exercise. And one of the things that you heard in there, and I do want to get to that discovery discussion in a second, because that is an important one. Does the judge have any real power to require these things and enforce orders, or will they be ignored and overturned? Another good question. So, and this kind of comes into the question of what the judge is willing to push. If this were another year, and the judge said, you may not put anyone else out into the field who does not have a body camera, which is more likely what would have happened. They would have given them the opportunity. They would have said either put fewer people out in the field or move people around, whatever you want to do, but they all need to have cameras. That probably would have been followed by anyone else. Objectively, this administration's kind of approach is to see what they can get away with. And to see what they can get away with within the law. Historically, we have not pushed the law this hard. And I have my own opinions on whether that's a good thing or a bad thing. But as for strictly legal, are they pushing it within the boundaries of the law? So far, probably. But they are pushing it way further than it's been pushed in the past. So that is this administration's approach, and that may be why they were elected. So I'm going to take a step back before there are some things I'll criticize and some things I won't. That is something I won't necessarily jump too hard against, because then we're getting a little bit too far into my opinion rather than the law. So Crispus says it's a stress test and a good thing. The counter argument to that is that this system that we have is not a system that has behind it a what's the word? An authoritarian approach. One that requires everybody to comply with the law. This is a system of consent. At the end of the day, our whole government is tied together with a consensual agreement. We have all agreed willingly to join in here, and it may not feel like that sometimes, but it is the philosophy that holds this government together. And if you keep pushing, you are going to find that all the way at the back, unlike certain other government structures that have historically existed, there is not a brick wall at the back. And that's intentional. We didn't want a brick wall at the back, but eventually the government's just going to tear apart. So you're not supposed, that's the problem with the stress test, is that eventually this government is not designed, if you stop consenting, which arguably if you push the law far enough, you're just not consenting to it anymore, then you can just undo the entire system. So that is the problem with the stress test approach here, is that it philosophically goes against how we've decided to put this thing together, as opposed to other systems like, the USSR, where at the back there was always this authoritarian regime that said, kind of forcing you to do this. So that's why you have to watch how far, that's the problem. So anyway, but like I said, that is the theory going into how far I think it should or should not go. Again, then we're getting so far into my opinion that I'm trying to rein that in. Yeah, there have been other places where we've had stress put on this before. I do think that the approach here is more about seeing how far it can be pushed. That is their approach, but that was what they said their approach was going to be, and they got elected anyway. That was what they said they wanted their approach to be. They were elected kind of based on that. And I'm not sure that a lot of people thought through the downside of that eventually. So, but whatever. Again, we're getting too much opinion there. Okay. So, I wanted to talk about the discovery issue. So, where was that? Oh, the subpoena question. Okay, so I have been Yeah, America has no king to fall back on. On the nose. Okay, so I have been. Oh, am I blinking? Sorry, Larry. Yeah, we're having some issues over on the TT again. So back to the subpoena question. I've been in a situation before where, as a government attorney, the opposing counsel has come in and said that they want to answer small questions. They want to bring in big people. For example, and if somebody on TT can tell me if it's stopped too much, I'll turn it off and turn it back on again. Let me know. In order to answer, small questions, they've required or demanded big people to come in. So we had there was a question about the administrative code, like our version of the regs, and because by law the the lieutenant governor was legally like the keeper of the regs, like that was his, I'm going to say ceremonial job. I mean, his office was responsible for making sure that the regs got kept up, but he was head of the office that kept the regs. So they needed someone to come in and confirm that, regulation 12345 said what it said. That's basically all they needed, was somebody to walk in and say, yes, this is what the regulation says. And so they subpoenaed the lieutenant governor to come in and confirm that, which is ridiculous. That is absolutely ridiculous. The problem is, as an attorney, we have a lot of flexibility when it comes to writing subpoenas. We can pretty much write a subpoena to anybody until the other side pushes back. Now, if they push back, they can request that the court consider some sort of sanction for overstepping the bounds. But to begin with, I can subpoena, as an officer of the court, as a lawyer, I can subpoena pretty much anybody I want. And so what I ended up having to do, especially because in this case we had a very short time schedule, I had to write motions to quash all of these subpoenas. They gave me 16 subpoenas for a hearing 3 or 4 days later over a weekend, which was, like 14 of them were ridiculous. It was the lieutenant governor, people just who did not belong speaking. But they knew that I wasn't going to have time to write 14 motions to quash because they thought I slept. I don't. So I stayed up for 3 days writing motions to quash, filed them all Monday morning and won them all, and I got sanctions against the attorney. But the point is that you don't have to. Okay, so I don't know what the rule may be different in different places. Where I was, if the lawyer issues the subpoena, if it's signed, it doesn't need a judge's signature. A subpoena, basically, they have the power to do it. Little do they know, we don't sleep. I am really stubborn, and I was not going to lose that. So, I also, wrote that they needed to be censured for that, and they were, because that was an abuse of the subpoena system. And I shouldn't have had to write 14 motions to quash because they were ridiculous. And chances are, if it had been like 2 weeks later, we would have been able to go into court and I would have not had to write them. I would have been able to talk to the court and they would have said, yeah, these are ridiculous. We would have had time for the court to say that. But we didn't. And so I actually had to write 14 motions that explained why you don't need the lieutenant governor to come in to confirm that this is what the regulations say. So what this judge was saying is, the attorneys in this case had subpoenaed Kristi Noem and Stephen Miller and all these people all the way at the top. And she said, based on your complaint, what you are complaining about is that officers on the ground are violating people's First Amendment rights, and that they're not, and maybe something, I think I got the impression, something about they're not being instructed properly. The people who need to come in and give evidence on that are the officers who need to come in and tell us what's going on. We need to talk to them, and we need to talk to the people who are instructing them to find out how they're being instructed, what they're being told. But we don't need their boss's 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 boss, even though they would probably be confirming the same information and how far up it goes. It's not important to answer your specific question. Now, she said, if you amend this case and you allege something else, because they were like, oh, well, what we want to allege is that these are these policies are intentional to go after people based on their opinions as a First Amendment violation. And so in order to prove that, we need to talk to the people who put the policies in place and who decided this is why we're going to do this. And she's like, if you want to prove that, you're going to need to allege that. And you haven't alleged that yet. So, we might be able to talk about that at some point. But for now, we're not subpoenaing Stephen Miller. We're not subpoenaing Kristi Noem. We will subpoena the director for Chicago. We'll have him come in and we'll ask questions. But that's not necessary to answer your questions. So that is what the whole subpoena question was and what they were talking about there. Do you think a mass education campaign for juror rights could stop some of the criminal charges against citizens and protesters? Absolutely. I think, I frankly, on several occasions, I've tried to explain to people how some of the rights of jurors and because I do think that's something that needs to be a little more widely understood. The role of the jury in preventing federal overreach. There was, I think, I don't know how many people were here the other day, but now I can't remember where I got this out of. It was such a great line, but somebody who equated the jury to the militia. As the jury is just like the militia in the state militia is there to act as a barrier to the federal government becoming too big and reaching beyond their constitutional limits. The jury acts the same way on a micro basis in each courtroom as a group of human beings from the local population who go in and have veto power over the federal government. So this is that was just kind of an interesting different way of putting that. All right, let me check and see what else we missed here. Let's see. So I had another big thing that I starred here, which was where the judge said, I don't know if you guys were here for it, but when she said she has a problem with, he was like, this was going to be such a big problem bringing in these cameras and stuff like that, and the judge said, well, there's a real easy way to solve this. And it got real quiet for a minute, and she said, don't violate the First Amendment. And he said, well, and she's like, no. Just, if we don't see tear gas at protests, then we don't need body cam footage. So just tell them to stop using tear gas. It's a protest. Just let them sit there and protest. And she specifically said, I got this list somewhere where she listed some things that I thought were interesting. She talked about the tear gas and about the pepper balls, but she also mentioned somewhere driving through a crowd with the car, which the thing is, that's really interesting because I think there is probably some disagreement sometimes as to whether driving a car through a crowd, whether the crowd is peacefully protesting or not. Because, of course, there's a lot of things where, you know what, Thomas Jefferson and Thomas Paine, you might be right about where that came from. We've seen a lot of things where people are trying to block ICE agents from driving and, sitting on the ground, stopping, whatever they're doing. And the fact that she specifically said you can't drive a car through a crowd is interesting. I'm not sure if that's what she was referring to or not, but it certainly is interesting. Because I would imagine that there would be some government attorneys, or at least some government officials, who would say that they are enforcing federal law, and the people who are stopping them are preventing them from enforcing the law, and therefore they are not peaceful protesters, they're violating the law. So that was just a very interesting comment for her to make. And, driving through pedestrians versus car, so this is the question: is blocking roads an acceptable form of peaceful protest? It's the kind of the classic nonviolent protest from the 60s. It is dangerous, but at what point does the government using having a car against a human body? What point is this kind of an uneven thing? Tiananmen Square is a good definition. The other thing she talked about that I don't want to forget is apparently in Chicago, same here in DC, we passed a law years ago, not years and years, but a while back, banning police car chases. And the reason is, I can't speak for Chicago. DC is very much a walking city. Most people in DC walk. People who live in DC walk more often than they drive. It's very much a walking city. A lot of people don't own cars. There are a lot of places where you're not allowed to own a car. They actually started, I want to say in 2015 or so, requiring, because in order to park a car, you have to have a parking permit. You have to have a sticker for your car that allows you to park in that area. And they started saying, certain buildings that were getting built, they said, this building has too many units to support that number of cars in this neighborhood. So this unit can be built, because they're usually knocking down 4 little houses and putting up, 25 units or something. And so they'll say, okay, we'll let you put up 25 units, but no one who resides at this address is allowed to get a parking sticker. And so they do that a lot in DC, especially as they started building more and more of these taller buildings. And DC, very much is kind of more, a lot of our laws are more about walkers than they are about drivers. They make it very hard to drive here, and that's intentional, because we don't, people who live here walk, and we don't want a bunch of drivers. Most of the people driving are coming in from out of town, and there's plenty of ways to get in from out of town without walking or without driving. All of the metro stops that are outside of town have big parking garages, so you can just park there and take the metro in. There's no need for, and the metro goes everywhere. But anyway, so we blocked the police from high-speed car chases in most situations. It's not every situation. If the person driving the car, whoever they're chasing, is themselves putting people's lives in danger, they're allowed to chase them. If they're on a highway, I think they're allowed stuff like that. But if they're going through a neighborhood and the person's, it's going to be more danger for the police to drive like that, the police aren't allowed to chase them. And Chicago apparently is the same way. And perp is good, yeah. One of the things that's recently happened since Congress has come in and started kind of rewriting our laws for us is they just are working right now, or they just passed, I'm not sure, a law that would overturn that and legalize high-speed car chases. And the federal government has also done it. So that's been a change. And so what she talked about that in Chicago, and she said that she's starting to see all of these car chases from the federal government where people are now there are car wrecks, there are accidents happening, and that's happened. We've had, I think they said, the last thing I heard, there had been 20 high-speed car chases in DC that were all federal agents, and 10 of them had resulted in accidents. And that's not safe. So she said, you know, this is a problem. We can't have that. There's a reason. She said, what did she say? It was something like enforcing laws and dealing with protesters in a city is different from doing it anywhere else. And I think, you know, Larry, I think this is part of what we're getting at here is that, you know, if we were in a part of the world where blocking cars was not more the norm, it is less likely for you to be able to. There are very few times. DC is only 10 miles by 10 miles at its longest point, and it is still going to take you an hour to get from one side to the other on a good day. So it being blocked is more the norm here than not. Not being able to get a car through is more normal than not. And so people who are trained, police officers who are trained to be here, know how to deal with that. And so they pursue on bikes. They pursue, you know, they find other ways to do it that is more friendly to an urban environment. And so it's just, and she was saying, you know, these guys are not trained to deal with protesters in an urban environment. They're not trained to deal with arrests in an urban environment, and that's part of the problem. So if we're going to have them here anyway, they need to start wearing cameras. They need to start, she's like, and she said it's better for you guys anyway, because if you're going to be accused of things and you're going to say it didn't happen, let's see the footage. And so if you have cameras on, then we'll know. Being a woodworker on U Street, yeah. Wes, it's right. You rent a car. It is so much cheaper to rent a car on the rare occasion that you need one, or, you know, than to own one here, because you just don't need one that often. I think I'm going to later today take an Uber to the grocery store and do a big grocery store run, because I'm out of things that I don't feel like carrying in a backpack, like, you know, sugar, you know, things that are heavy. But you do that every once in a while, and you just get used to that. So, all right, tell you what, guys, I'm going to wrap up. But thank you all for joining, and I think this was I think very important, and that's, you know, I didn't do a morning report today because I thought this was an important thing to do. I am going to be working. We got another case tomorrow. I don't know what's tomorrow. As of right now, my plan is to just do a morning report tomorrow because it is Aloha Friday, unless something big comes up. Next week, we don't have Supreme Court cases. Don't have Supreme Court oral arguments, so I'll be able to get back to normal schedule, at least somewhat normal for a little while, once I get some sleep. Because I will tell you guys that in general, doing the Supreme Court oral arguments is a lot of work, but that Calais case, that knocked the wind out of me. That was a lot of work. So anyway, thank you all very much, and I will update you as we hear more stuff. All right, and I'll also tell you, I'll probably make a video about this and about if I do see the new TRO come out, I'll let you know. No, but the French Castle, yeah, it's a beautiful walk. All right, bye everybody. Have a great day.